Kia ora tātou. Nau mai kia koutou, rauranga tirama i te whānau, ka nui te mihi kia koutou, ka nui te mihi kia tātou, mō tēnei wā ko Māmari tōku ingoa. I'm just going to start us off with a little karakia, which the object of the karakia at an event like this is to kind of bring us together in a spirit. And this particular karakia speaks to a spirit of connection, of peace, of strength, of mana, and of it's almost like a blessing, this karakia that I'll be doing, a blessing for the kōrero that's going to be delivered. And then I'll finish off our event with another karakia to kind of just lift the tapu, if you like, and allow us to all go back into our ordinary lives. Nā reira, e hoa mā, ka nui te mihi kia koutou. It's lovely to be here. Kia ora. Mahea, e te wairua tapu, tō ata whai tau mai kia pai, tō manaaki tau mai kia pai. E te kāpura, e te whatu, e te hukarere, e te kohu, e te tūpuhi e mahi nei kia pērā anō te kōrero nei e. Whakakaroria koe, whakanuia ka tika. Kia tau mai te rongo, kia mau, kia kia whauka, kia ita. Tuturu whakamaua, kia tina. Haumi e, hui e, taiki e.
Ladies and gentlemen, tēnā koutou, tēnā koutou, tēnā koutou katoa. Good evening and welcome, one and all. It is both my pleasure and my privilege to welcome you here tonight for what I'm sure will be another interesting and thought-provoking lecture in a series which has been established in memory of Lecretia Seales. For any first-time attendees, this is an annual event hosted by the Law Faculty and made possible by the continued support of Lecretia's friends and family, foremost of whom amongst us here tonight are Lecretia's parents, Shirley and Larry, and also her brother, Jeremy, and it is great that we have you here. This series is a tribute to Lecretia's passion for law reform. Today's lecture, the 10th in the series, will be presented by the Centre for Justice Innovation and considers custodial remand as an illustration of the complexity of addressing criminal justice problems through law and policy reform. As well as being my pleasure and my privilege to introduce tonight's lecture, it is also somewhat of a surprise. A surprise for anyone who knows me and has not seen me in these pastures for many a year. Over the course of quite a long time, I've been based in each of Australia, the UK and France. In fact, I'm currently living in Switzerland. It's a long way from Zurich to Wellington. As a result, I'm somewhat of an unlikely attendee at this presentation. In addition to being a surprise to others, tonight is also somewhat of a surprise to me. I was delighted when I realized that my current visit coincided with tonight's lecture. This is only the second lecture that I've been able to attend, but I'm not sure that I ever anticipated standing here and introducing it to you. A special thanks to my father for volunteering me for this task. So for those who don't know you, my name is Christine Robertson. I'm a semi-retired Kiwi lawyer who has been based offshore for many a year. The reason for my attendance tonight is primarily that I am an old friend of Lecretia's. We met last century, literally, when we both started together as law clerks at Kensington Swan in 1997. Lecretia and I became firm friends and remained so for the following nigh on 20 years. For anyone who didn't have the privilege of meeting Lecretia, then I really can say, I'm afraid, it was your loss. She was an amazing woman, who I will always remember for her exacting intellect, her indomitable spirit, and a particularly mischievous sense of humour. I have absolutely no doubt that Lecretia would think it was hilarious that I was standing up introducing this lecture, having thought I could sit quietly in total obscurity in the audience. Her widower Matt, I'm sure, is also chuckling at me. Over the course of her legal career, Lecretia developed a real passion for law reform. She worked at the Law Commission and is well known for her incredible fight in the reform of assisted dying law in New Zealand. She was one very determined lady, and she fought bravely for much longer than any other person could possibly have fought. The previous 9 lectures in this series have covered a broad range of topics, all relating to various forms of law reform. Tonight we will hear from the Centre for Justice Innovation about their most recent study into custodial remand. And without further ado, I welcome and hand over to the team from the Centre. Thank you.
Kia ora koutou, bula vinaka, and good evening. Thank you, Marmari, for that lovely karakia, and Christine for your kind and really touching opening remarks. Thanks too to everyone here for spending your Thursday evening with us. A special thanks to our families who are here in support, and including Alex, our Centre Research Fellow's parents who have travelled from Whanganui. When we were asked to give this year's lecture, marking 10 years of remembrance and celebration of Lecretia's determination and perseverance, the whakatoki I oria tu tuatara ka puta ki waho seemed appropriate. Like poking a tuatara out of its hole, our work involving justice reform requires persistence, adaptability, and creative thinking, an innovative approach to cross-cutting justice problems, not unlike Lecretia's creativity and persistence in her own battle for law reform. In honouring her, we feel privileged to give the lecture this evening. And it will be a team effort. So there's going to be me, who's one of the Centre co-directors. I'm Yvette Tinsley, one of the academics in the law school. Alex here, who is our research fellow, Alex Forlong. We've got John Walker, former Judge John Walker, he doesn't like me to say that, one of our Centre co-directors, and Everard Halbert, who's the third Centre co-director. So we're all going to be pitching in. Hopefully that means you don't get bored of just listening to one voice. I was joking before, I'll keep popping up, like, only me, back again. But all of us will be talking to you tonight. So over the next 40 minutes or so, we'll discuss some of the findings from one of our latest projects, as Christine said, on custodial remand before trial and sentence. And that's to illustrate the complexity of justice problems and of attempting reform in justice spaces. Like other common law jurisdictions, New Zealand experiences consistent calls for criminal justice reform, but there's typically a lack of consensus about what that reform should entail, or even the direction it should move towards. Scholars such as Lattimore in the US have argued that punitiveness is built into the US system, and the work of Pratt and others here in New Zealand suggests that may also be true closer to home. But when punitiveness drives the process and its reform, we're inherently limited in the change we can achieve, because the measure will always be punishment and punitive responses to harm. Indeed, over the years, it's possible to see that perceptions of crime and those who commit it have tended to influence policy and law reform regarding bail in community and in prison, custodial remand. It's also influenced public discourse about it. Custodial remand and bail has become an exemplar of reactive reform. Valid concerns about risk led to legislative, policy and practice changes, only for it to emerge down the road, as we will illustrate with some high-level results, that by seeking to prevent harm, we've also caused it. So here's a little look into the world that we're living in at the moment. And thanks to Alex for putting this together. So this is the complex web that we're looking at in terms of the things that we've found around custodial remand before trial and sentence. And that's before we even start to then think about its place within wider social justice problems. So feel sorry for us that we're trying to navigate our way through this. What you can see from that is that remand's an issue where we can see all the problems of the criminal justice process locating, multiplying, and potentially becoming intractable. The question for us then becomes, if we know there are harms, strains, and stressors because of current settings, how do we address it? Once you have the evidence base that reform is required, how do you achieve it effectively and safely when the complex web of criminal and social justice is at play? How do we avoid pulling on one thread in the web and harming people at another point? We believe that what's needed is, as says in our Wakatoki for this evening, persistence, creativity, innovation in continuing to try to find solutions, all based on objective evidence carefully gathered through original independent research. Now, in puzzling through how we address the harms our current settings are causing, we're formulating numerous recommendations in this project for short, medium, and long-term reform, but none of them will provide a silver bullet solution. When we try to unravel remand levels, we may wish to investigate reform of bail laws themselves and of prosecutorial and judicial risk assessment practices. But we can't stop there. It cannot only be reform of the law itself or even criminal law policies that are contemplated. As Ashworth observes, the criminal law is a conservative force, prescribing coercion to enforce conformity with the norms of those with dominant interests in a given society. And as such, it works to keep us within certain reform limits. So we need to be able to innovate, to be thinking beyond the limits of the criminal law if we're going to achieve real change. So we argue then that reform of the law and practice can't change negative outcomes effectively without also doing more. Reforming what alternatives are available to remand in prison, how we treat those incarcerated on remand, and the interplay of socioeconomic and environmental issues impacting the use of bail conditions and electronic monitoring. Legal cultural behaviours are as influential here as is the law itself. We acknowledge then that the recommendations coming from this wonderful web will only be able to go so far while more system-wide issues persist. How do we achieve sustainable change? What will really make a difference in justice reform? As tonight's Wakatoki suggests, we need to persist in looking for solutions and to engage a more creative, adaptable, and innovative approach while we do so. Our view, as a team, is that change must go back to basics. Big system, as well as small measures, a long-term approach that looks to educate professionals and communities, putting trust in community experience and how they can help to repair what society has broken, and a need to have a creative vision beyond reform of the law itself. So, for the rest of our time together this evening, we're going to use this work that we've done on custodial remand to reflect on how we might seek to find those solutions without causing unintended harms. How to start that is, of course, in itself complex. Just as no single reform project can offer a silver bullet solution, we can't provide a roadmap to successful change in the course of one lecture, sorry to disappoint, perhaps not even in the course of our careers. But we do hope that we can highlight some potentially fruitful directions and prompt lively discussion. So in a moment, Alex and I will introduce the project, some of our key findings about custodial remand and some of the potential reforms, big and small, to the law and justice practices that show potential for some of the solutions we seek. And after that, my two other centre co-directors will take over. John will draw on his wealth of experience within the criminal justice system to discuss why sustainable change requires education of all players, and that such education requires the law to embrace the knowledge of other disciplines. Education of legal professionals and others working in the justice process is an important part of our continued search for solutions. But what we learned in this project is that the education of community is also integral to successful reform. Only a community well versed in the evidence can have informed debate. As well as the need to educate community, there's much we can learn from community, especially those who are already dealing with the harm that custodial remand causes. Who knows community and its potential better than those working within it? Our co-director Ev will reflect on what the community has told us about their role in justice reform and the often untapped potential they have in our search for solutions. So now over to Alex, who will tell us about the project and start to tell us about some of our findings. Thanks, Alex.
So our team were prompted to look at custodial remand after seeing the continued growth in both the numbers of people being remanded in custody, but also the length of time they're staying there while waiting for trial or sentencing. The most recent public figures show the remand population is encompassing 40% of the total prison population, which rises to 51% for women. Approximately 2/3 of these people are people who have not yet had a trial. There are principled objections to rates like these. We're imprisoning many people who have not been found guilty, potentially keeping them waiting in prison for longer than they would ever serve on a sentence, leading to the concept of time served. While on remand in prison, many are kept in their cells for 22 to 23 hours a day, with limited access to courses, work, exercise, material goods, as we'll talk about later, even some of the basics, phone calls, lawyers, and family. It may not be conceptualised as punishment, but there's no doubt that it is experienced as punishment. For the system, we're losing rehabilitation opportunities. We're putting strain on courts, on prisons, and on prison staff. So our project has decided to look at three kind of areas of this problem. We're looking at the application of current bail decision-making law and practice, the experiences of being on custodial remand, but also the impacts of remand on individuals, whānau, and the community. A range of data points have fed into our project, including desk-based information, written bail decisions, court observations, a survey, and conversations with the community, justice professionals and individuals with lived experience. We should acknowledge here that all of our data represents a snapshot in time. We collected data from 2023 to 2025. Our interviews are qualitative and rich, but have limited numbers, especially for women who are in custody. Our hui are not representative of all iwi, but rather only those community members participating. Further, interviews and surveys are reflective of the people who participated. We're sharing their stories and their perspectives. However, the combined consensus of all our data points and the groups we've talked to gives us confidence in our findings. The findings we're going to talk about tonight draw mainly from the interviews and the discussions with community representatives. So for the purposes of today's conversation, we're going to begin the criminal justice process at a bail application stage. Now, for those who may not know, bail is when someone gets released into the community whilst awaiting their trial or sentencing date with conditions, such as having a curfew or perhaps being electronically monitored, to manage any risks that they may pose. Bail was described by one judge as one of the hardest aspects of the role, and this sentiment was shared by other justice professionals. A range of information is given to the court during a bail hearing. Prosecutors will discuss the potential risks that a defendant may pose, such as further offending or not complying with conditions, whilst the defence lawyers will highlight how these risks could be mitigated. They'll also put forward some contextual factors to help the judge make their decision, including whether the defendant is employed, whether they're a primary caregiver, or their housing situation. These arguments are then used by the judge to determine whether the risk posed by a defendant being on bail can be mitigated by conditions. There's no one structured tool used to make this decision, rather professional judgment and the limited information put before the judge. As you can imagine, good representation is important in getting good outcomes for defendants. However, some men who'd previously been on remand in prison felt unheard in court, noting that some justice professionals seem to lack an insight into the realities of remand. This was somewhat confirmed by professionals themselves, including a prosecutor who said they'd like to visit the prison because they want to know what they're sending people into. Women in custody also told us about negative experiences with their lawyers, including a lack of communication about potential outcomes or delays. Communication can also be key between legal professionals in terms of finding solutions, but also from the judge in terms of managing the tone and expectations of the court. We also heard that the threshold for being granted bail can be high, and this can result in a number of conditions being imposed on a defendant. Given the delays of the current criminal justice system, taking a year to a jury trial, people are living with these conditions for lengthy periods of time. If they fail to comply, there can be lasting consequences, including convictions. Despite the difficulties of being on bail, there are few supports available to help the people who are there. As I mentioned before, delays are really common in the criminal courts and complex to resolve. Internal and external resourcing are both key drivers, with insufficient infrastructure as well as a lack of justice and health professionals feeding into this. Some delays are considered unavoidable. For example, bail reports will take 2 weeks to write, or a case review hearing needs to be scheduled 6 weeks after a plea is entered. However, some professionals felt that there is a cultural lack of urgency within the system. Delays have been accepted as unavoidable and therefore left unquestioned. Everyone suffers when hearings are delayed, but those in custody face the worst outcomes. It can impact decisions that individuals make about their own cases, but also the decisions the professionals around them are making. As one defence lawyer said, "We're getting to a point where a lot of people are pleading because it's time served, and then getting an imprisonment sentence on their record when they probably wouldn't have gone to prison." Judges acknowledge that there are ways we can mitigate delays through things like using technology and better supports, but care is required, as efficiency does not always lead to the best outcome. For example, if someone is sentenced without adequate reports. If someone is denied bail, they are remanded into custody. In New Zealand, most people on remand are placed in a shared cell in a high security unit. These physical conditions are challenging. There's a lack of privacy, and participants in our study were spending 18 to 23 hours a day locked in their cells. Even how long you spend out of your cell can be unpredictable, with this changing on a daily basis. When released outside, high security units have enclosed outdoor spaces which lack any green areas or grass. As one woman put it, "It's grey in clothing, the rooms are grey, everything is grey. We sleep on stainless steel, but it's even the mood. It's not a very enlightening place." Unsurprisingly, this inherently negative, often volatile environment adversely impacts mental well-being. Uncertainty feeds this deterioration, with remandees not knowing what's happening in their personal life or in their legal case. Everything is out of their control. To add to this, safety can be a major concern on remand, both in your cell and in your unit. We heard that you have to adapt your behaviour to the environment, but that safety can simply depend on who and where you are. The influence of gangs contributes to this lack of safety. People are often pressured or incentivised to join the gangs. However, membership does not necessarily provide safety and often leads to increased conflict and a requirement to follow the orders of those more senior. Contributing to the challenges of remand is this somewhat unique culture of the environment. The men we spoke to described prison as being like its own society, where unspoken rules govern your interactions and interpersonal skills are incredibly important. You can be reprimanded or rewarded depending on your behaviour, and there's even separate mechanisms of currency, such as for trading things like nicotine lozenges or medication. Women told us about how the environment is not designed for them, and as one put it, they rip away every bit of femininity we have. It's not promoted nor enabled, and even things like the nutritional composition of food appears to be optimised for men. Traumatic life histories are common, and many of the women we spoke to said they had not received support for this. To cope with being in this new, unique environment, people on remand utilise internal and external coping strategies. We heard about the need to manage your own well-being, finding ways to stay active and keeping on top of your mental health. Maintaining perspective is also considered important, having a positive attitude and mindset wherever possible. Some people felt like their previous life experiences somewhat prepared them for the environment, meaning they were less shocked or found it to be less confronting. Externally, people leant on each other for support, both emotionally and practically, making relationships a key coping mechanism. We also heard that good relationships with staff can be a positive thing. I'll hand over back to Yvette.
Thanks, Alex. And I think it must be remembered that for a good high percentage, around 2/3 of people on remand, they have not yet had an adjudication. So they've not yet been convicted of anything whilst being in their cells for between 18 and 23 hours a day with limited access to all the things Alex spoke about. And on that, I want to talk a little bit more about difficulties getting the things people need. So a significant challenge for people on remand is getting access to people as well as things. One example of that, which is a really serious one, is being able to actively participate in the criminal case by contacting your lawyer. There are mechanisms on remand for contacting or seeing your lawyer, but there are many barriers to that happening. There are high demands for the secure phones. There's a limited time where calls can be made. Remandees talked about trying to find ways to work around it, including calling their lawyer from non-secure lines, which FYI is not a good idea. Seeing your lawyer in person wasn't always possible, with remandees not always travelling to court, which is one of the places where they might ordinarily see their lawyer. Lawyers struggle to get out to prisons or struggle to get access into prisons at the right times. So that can make aspects of trial or hearing preparation incredibly difficult. And we know from international research that people remanded in custody have poorer outcomes in terms of their case. There are other impacts too. Some people are able to use remand as a way to get some basic healthcare, so primary healthcare checks that perhaps because of their lifestyle they hadn't been able to access on the outside. But others really struggled to see medical professionals while on remand. There were long wait lists, especially if you needed anyone who was a specialist, especially in relation to mental health, and that left a lot of remandees we spoke to struggling. Some of them were unable to continue medication they had been on the outside, or certainly not without a delay, and sometimes that had quite serious consequences. Poor access extends to provisions, activities, formal supports. Not everyone has money to buy extra food or products from the canteen. Not everyone has family willing to send them in extra clothing from the outside. And when we talk about that being a problem, that can include deprivation of the very basics. As one woman said around underwear provisions, they had a bunch of new girls come in, they didn't have any socks left. So we've got heaps of girls here that don't even have socks, or they just have one pair of undies and they're cleaning them in the shower to wear them the next day. We also heard about people having to share laundry bags and laundry bags that were broken, ill-fitting bras, all of those things. So we're talking about the very basics of provisions. Coupled with that is a lack often of formal preparation for entering remand. So some talk to us about how the formal induction process was insufficient for their needs. Remandees talk to us about relying on others in the unit to learn the nuances of being in prison, such as when do you push your towels out for collection? That wasn't in the induction booklet. Wouldn't have known if another prisoner hadn't have told them. Case managers, whose role is to help you plan for your time inside and eventual release, could be challenging to get in touch with and were limited in the support they could provide. Now, for some people who are on remand for months at a time, this becomes a particularly difficult issue. Coupled to that, think about spending all of that time in your cell. There's simply not enough to do when you're on remand. Programs were appreciated, but the range of programs offered was limited. They were often oversubscribed. There could be barriers to engagement, such as the program being group-based. Similarly, those who were able to get a job appreciated the time it got them out of their cell and kept them busy, but there aren't enough roles to meet demand. Now, life outside doesn't stop when you're on remand, but when you're inside, managing your affairs outside is incredibly difficult. That can include trying to find accommodation so that you can apply for bail, juggling cancellation of your benefit, which happens quite quickly. Whānau support's critical financially, emotionally, childcare arrangements, administrative delays with the prison can contribute to struggles with issues getting people added to your phone list, difficulties in sending or receiving mail, and difficulties in getting property from home. And one man described the process saying, you've got to fill out what you're asking for, send that in, give it to the guards, they give it to the PCO, he looks it over, signs it, sends it back to you, then you send it to your family, and then they have to send it in. And to do all that process, it can be 6 to 8 weeks. Now, as that suggests, remand impacts more than the individual who is remanded in custody. Remand's got complex implications for whānau, as well as for the people who are remanded themselves. There are multiple ways that people can try to connect with whānau and friends while they're in prison, including phone calls, writing letters, and visits, but there are barriers to utilising these. So, for example, remandees might enter the prison without their cell phone. They may not have had this on arrest, it might have been confiscated by the police. So that means if they want to make any calls from prison, they have to be able to remember the number off by heart. And I don't know about any of you, but I'm not that great at doing that. Even if they have the number, they have to get that number approved by the prison, which takes time. Phone calls can only be made during unlocked times, which might only be 1 or 2 hours a day. And as one woman said to us, you've got 60 or 70 women all trying to get to the phone within that space of time. Calls are restricted to 30 minutes a day. Beyond phones, not everyone can write a letter. Visits are not always practical for whānau, especially when their loved one is located away from home, which especially for women is usually the case. Yet contact can be vital. When someone's taken into custody, their whānau are left to pick up the pieces on the outside, organising childcare, finances, and in some cases trying to help with the legal process. That can be frustrating and upsetting. Those on remand are conscious of that burden, and some try to avoid adding to it by foregoing visits or phone calls. And one man said to us, "This was my decision to go. My choices put me here. I don't need my family to come and see this place because of my decisions." So here's a few of the things that we're investigating as potential justice-based solutions. What to do after all of that, all the findings that we've kind of come across. We know it's incredibly challenging for individuals to break free of the criminal justice system once they're in it. People often have complex histories of trauma, potentially state involvement. They might gain new gang or criminal associations while in custody. Remand changes the lives of individuals and their whānau, and it can have long-lasting impacts on their perceptions of the justice system. So here you'll see a selection of potential solutions to the pain points we've identified in the study. Some of them target the law itself, some target court-related issues such as risk assessment, delays, and legal professional education. Other possible solutions aim to improve the experiences of people on remand and of their whānau left on the outside. We heard overwhelming support for more community-led solutions, things like iwi or community advocates in court, supportive bail accommodation addresses, more reintegration support, which Ev is going to talk about a little bit more soon. But those supports require funding and resourcing from the state in order to work effectively. You'll also see mention up there of remote participation, which refers to defendants appearing from court from within prison rather than enduring lengthy, uncomfortable travel for short pre-trial appearances. Our research has shown there are mixed feelings on appearing remotely. People don't want the travel, they don't want to potentially lose their cell, but they sometimes would rather be in court face-to-face. We're exploring that further in another project at the moment. So these potential law and practice reform solutions range from small changes to big, wider system issues. We think such reforms have potential to make a real difference to the way the system works, but they're not going to fix the problem of custodial remand in its entirety. There's a valid argument that without wider social justice change, any improvements will be negligible. We started the lecture with an illustration of the complex web our research revealed, and in our search for solutions, we believe we need to go beyond the reform of law and legal policy. So I'm now going to pass to John to speak about the importance of community education in building awareness of the evidence we've gathered and putting a human face to those remanded in custody. And then Ev, who will speak about the potential for community to bring solutions that address harm safely.
Thank you, everybody, and it's a great honour to be able to be present at this very special lecture and to be able to share with you the work that the Centre has been doing. Courts administer justice on behalf of their public. The authority of judges is bestowed by the communities they serve. Yet communities and their courts have become separated. There is a disconnect. Communities do not see courts as part of the community. They are seen as something separate. And when members of a community see courts at close quarters, enter the courtroom for whatever reason, they find a mysterious place, a place of ritual and of strange language, a place which is continually confronted with the symptoms of complex problems facing communities and searching for solutions within a legal framework. Homelessness, mental illness, intellectual disability, neurodiversity, including fetal alcohol spectrum disorder, head injury, autism, exposure to childhood trauma, drug addiction, disconnection from culture, all highly prevalent in those who come into conflict with the law and come into our courts, and are all drivers of offending behaviour. But these conditions are not susceptible to responding to a legal consequence. You cannot punish somebody out of a disability or an addiction. Dealing with these complex underlying issues requires courts to look to communities, where, in my experience, the solutions are so very often to be found. Two things need to happen to unlock the resources of communities to address these issues. First, it's for the courts to open a pathway for communities to connect with their courts. And secondly, educating the community about what is happening in the courts and in our justice system so that communities can understand where they might help. What do communities know about the consequences of remand in custody, pending trial or sentence? Do they know that people are locked in their cells for 22 or 23 hours out of every day, sometimes for months and months on end, sometimes on their own, sometimes with a stranger? Do they know, the communities know, that while this is happening, there is no or very limited access to interventions to address why they are there? Do they know that in increasing numbers, people are in custody longer than any sentence would have been? The concept of time served is often a euphemism for they've served longer than they ever would have. And these are the people in these remand situations who have the myriad of mental illness and other issues to which I referred earlier. They are, for the most part, the most vulnerable. If communities did know this, I doubt if they would think it right and would want to look for alternatives. In my time as a judge in leadership roles, I was exposed to seeing the figures for those on remand in custody, which was an increasing number over years. But it wasn't until I went to visit the remand wing at Rimutaka and stood in the block of cells, tier upon tier, and just saw pairs of eyes looking out through the inspection hatches of their cells, where they spend so much time. The power of being exposed to the reality behind the statistics. I know also from my time as a judge how often a remand in custody happens because of the absence of any alternative arrangements in the community. The risk of offending on bail assessed as high unless there is some supportive accommodation able to manage the underlying drivers of the offending behaviour. The engagement and resourcing of communities to provide alternatives could be part of a solution. But communities have to be part of the discussion. And to do this, they need to understand the issues at play. Law reform is not just legislative change. It can be changes in approach and changes in culture. Drug courts, special circumstances court in Wellington, dealing with the underlying issues of homelessness and mental illness. Young adult list in Porirua, dealing with those under 25. The District Court Vision Te Ao Marama are all examples of change in approach and culture in the courts without any legislative change. These changes are also examples of where the community resources have been brought into the courtroom. I see the Centre's role as not only providing the evidence for informed debate on justice issues, but also in educating the wider public, bringing them into the justice discussion, informed, trusted, and heard. Te Ao Marama seeks to do this in its responses to decades of calls for changing the way in which courts operate. But effective engagement with communities needs the education I have talked about. There's also a wider need for education beyond legal frameworks if there is to be sustainable change in the way the courts operate. There's a need to ensure that all those who play a professional role in the courts share a common understanding of disability, for example, and the barriers to participation that disability in all its aspects throws up, and the consequences of decisions made in courts and positions taken. Our research will provide information on the consequences of remand in custody, but there is a need to bring into the discourse the expertise of other disciplines, psychology, criminology, and linguistics, for example. One of the strengths of the centre, based where it is in the law faculty at the university, is to bring in to the discussion the expertise of others outside of law. The Centre's research into the use of AVL, remote participation in the courts, has an early emphasis on the effect of technology on those with disability. Is it a help or a hindrance in an individual case, and how do we know who's who? This is not a legal question, but one which needs the expertise and lived experience beyond judges and lawyers. We see the Centre as having a significant role in addressing these education issues. I hope that the dogged determination of Lecretia in the pursuit of change will continue to inspire us at the Centre and inspire all of you. Can I now pass the baton to Everard, who has engaged with communities in the course of the research and knows the richness of the contribution that they can and are willing to make.
Ka tira tēnā koutou, me ki māmari tēnei te mihi atu ki a koe, I rongi tō karakia tino tāhu kei te mihi. Christine, tēnei te mihi atu ki a koe, tainu atu ki te whānau o Lecretia. He hōneri tēnei ki te tū ki te kōrero I tēnei wā, he wā pauna mo nō reira kei te mihi. Kei aku rangatira tēnei te mihi, tēnā koutou, kāti, kia ora mai tātou katoa. So just acknowledging Māmari for her karakia, Christine for her lovely kōrero, and to the whānau. It's an honour to be in this space that you bring us together annually in. So kei te mihi, and to you all, my acknowledgements. So reform of policy and law is always going to be complex, but the community wants to be a part of it. When the centre was launched in this room, we heard about the path ahead, and that path ahead to improve the justice system was always going to mean working with Māori and resourcing the Māori community. So working with Māori organisations and working with iwi. So after that launch, and when we held this project of remand, we went to talk to 22 people and 3 organisations, Māori organisations. One was a marae down in the South Island, another health organisation down there, and one up here in the North Island. And we asked them, these organisations, to bring together people who have experienced remand or who can offer a voice on what's happening. So those people included CEs and managers of those organisations. It included health workers, Māori staff, past corrections and MSD workers who now work for those Māori organisations, and people who have lived experience. Those organisations don't only work in the space of remand and prison, they also work with people who have been harmed with victims and people who have caused that harm with offenders and others. But when we had a kōrero with them, we said, please bring these groups together, and we spoke about this topic of tonight, about remand. So we asked them, what's your experience of remand? What's the impact of it? And what are the ways forward? What ideas do you have? So the first question was, what is remand? And when we asked that question, the providers wanted to start in a place where they said, you know what, here's the terrain of Aotearoa, New Zealand. And we had our own legal system here before 1840, where we drew from our Māori values and our tikanga. So asking the question, how do Māori fit into the mainstream legal system, might help in some spaces. But they also asked us, what would it be like if you asked whānau, hapu and iwi, what's the starting point? If you ask them first. So after talking about those things, after talking about their Māori tikanga and way of being, they turned to the question of remand. They said it's a mainstream system, not grounded in Māori values or tikanga. And you have the quote there, there is no tikanga process within that court system. You're in a mainstream situation. There's no consideration. It just points to a total lack. There is no treaty partnership. And when they spoke about that lack of treaty partnership, they spoke about the lack of voice, the lack of choice, and about not doing things together. Another point they made about what their experience of remand has been is that there is a flow that goes into and along the justice system towards custody. And the quote there for that is, this flow doesn't allow for time, it cannot be slowed, and it doesn't allow for intervention. And when we went around those three different organisations, that's what they want. The community wants intervention. It wants to provide alternatives. It just needs access. So our second question then was, what's your experience of the impact of remand in custody? And what have you seen? So in their view, remand causes life-changing harm. And some of the quotes that some of the participants said was, I would rather go straight into prison than be in 23-hour lockdown. So by that meaning, they would rather go straight into sentence prison rather than being on remand and being in the lockdown that we have heard about tonight. They said people are taking their life in remand. It's actually the hardest space in prison. They said the well-being just gets affected massively across all aspects of well-being. And as has been said tonight, violence, disconnection, uncertainty, that all has an impact on the individual. One of them did mention that the guards in custody spaces do try and help. But then he said, the problem is that they wear the wrong colour. So this harm extends to whānau, and then it moves through the whānau into the tamariki and mokopuna who wear the wounds. What they said about that was, there's also an intergenerational impact. If there are mokopuna, tamariki within the household you've left, their view of the world changes. Their view of their papa, of their mama changes. Their view of the police and the system changes, and actually that can become a trauma-based historical problem that arises later in life for that individual. So it's not just about the individual on remand. We've heard about that tonight. And so they said, if we have a human in front of us, and we see that 1, 2, 3 things have happened to them, 4 and 5 have happened to them in their lifetime, beginning from when they were kids, then it's a no wonder they end up in this place. It's a no wonder they're on remand, showing again how complex it is to make a difference. So then our third question to them, what can be done better? Because these are the people who are trying to make a difference every day. When I asked them at the end of what was sometimes 2-hour and 3-hour kōrero, and it was meant to be 1 hour, at the end of that I asked them, what keeps you engaged? What keeps you so committed every day to this, and where do you get your energy from? And one person said, I count in ones. because after I've met all the people throughout my day, when I get home, I just hope that I have managed to help one person. So on their ideas about what can be done before remand, before people move into that place, was they want to engage the community before the person enters into the flow that we spoke about. And so the CE of the marae said, why couldn't I go in there as a whānau member and just say there needs to be a cooling down space? Because they know that there are times where there's been harm and a person needs to be removed from the community and looked after in some other way. But what she's saying is, maybe the whānau can do that, and maybe the marae can help. And so for this case, for example, actually remand might not even need to be an option. They also spoke about, before remand, before custody, you can use Māori models of support. One is what Yvette spoke about, the iwi advocates. So one of the organisations said 10 or 20 years ago, he remembers sitting in the courtroom where there were Māori iwi advocates, and they got on very well with the lawyers, they got on very well with the judges, and sometimes the judge would ask for their opinion. What do you think we should do with this human that's in front of us now? And they found that helpful. The other model was Te Paioranga, which is in the police space, pre-charge and warning space. That's where it started, at least. It's moving into other places now. But Te Paioranga is a Māori model grounded in Māori culture and Māori values. It used to be called iwi justice panels, but it brings together the person that was harmed, together with the person that caused that harm, if they both want to be in the same place and safe. And it tries to find out what's the harm, how can we address it, and what's the way of moving forward. And so sometimes it's not a justice issue, sometimes it's a health issue. So in that community panel, you might have a counsellor there in drugs and alcohol, and that person can simply raise their hand and say, you know what, on Monday morning at 10 a.m, come to my office and we can start. So there's no waiting space. They also spoke about Māori community housing, and the marae joked about the land that was next door and said, how can we get hold of that? Because the council owned it. But they said, if we could get a hold of something like that, if we had the resources, we could build housing for people instead of putting them on remand. They also said, we know that judges don't want to send everybody to remand, but sometimes in that courtroom, it looks like there's no plan B. And Māori are saying, we want to be that plan B, and we've got a plan C after that. They just want their voice in the space. So 3 ideas then on during remand. We have a lot of these ideas, but we're going to put them into a chapter, and that's going to be published at some point. And I can see Alex is looking at me because I'm going to probably be going over time. A few minutes to go. So during remand, they had ideas as well. They said, the community wants to support people while they are on remand too. And their quote for that is, it's the same behind the wire. They need support straight away. And that support could look like kaimahi Māori or Māori staff from organisations getting access to people on remand. Because these places, like the marae and Māori organisations, have lots of contracts. And some of them are able to see men who are in the sentence space in prison, but they're not allowed to see people who are on remand. They want access to be able to do that. One thing they could do, they said, is create a plan for each person, so that when they left when they left prison, they could then be connected back into the community. They spoke about kaumātua being able to go into that space. That used to happen, and apparently it worked well. And even they tried to do it online and remotely, and were unsure how that would work, and it worked well. The problem was there wasn't any resourcing, so these kaumātua didn't get even the money it cost for them to drive out there for their petrol. So that faded out, but they want to bring that back with funding. And as another example, just allow the community to run programs. If the problem, because programs are allowed for sentenced people, but not for people on remand. Well, it's hard to do anyway. And so the Māori community is saying, okay, if it's uncertainty, you don't know they're going to be there for 6 weeks or not, let us do a one-day program. Last page. So then to finish, change needs willingness and resources. It needs other things, but it needs those too. The community said there needs to be change. And when they were talking about that, they said, we need to be careful of the system that pushes back against change. And their quote there, the system is all about perpetuating the system. It justifies itself and its existence. So those are the two things, willingness and resources. And the problem with resources is that for these things, sometimes they don't exist, sometimes they're low, sometimes they're temporary in terms of pilots. When someone's got some money, the pilot works or needs to be developed, but there's no more money, it's stopped. Sometimes there are significant resources that are allocated, but then they get moved to some other thing. So change needs the community support in the difficult and complex space of remand. And that's what they said. There'd be a real community willingness, but it just needs resources, the reality of these resources. And finally, when I ask them, when I go to people to talk about your stories and what you have told me, what do you want the most to know? And they said, what we want the most to know is to hear the harm, to find the willingness, and to allocate resources. Mō reira, tēnā koutou, kāti, kia ora mai.
Thank you, John and Ev. So, solving the problem, continuing to find solutions in order to solve the problem. We've seen that in order to undertake effective law reform, we think that wider system change is needed outside the formal settings of the criminal justice system. Other social and educative measures are vital. That's not a one-off or a speedy process, it's a process of societal change. So we think we have to modify our expectations so that conversations can be had about cross-party, long-term investment in change, in community programmes that empower Māori and other communities, and about challenging some of the ways we do things. Solutions to the problem of remand are therefore not found at one location, but at many. They are system-wide and they are located outside the system. So iterative but bold change in an agreed direction across justice and social agencies is the innovation we ultimately hope for. So we hope that our work's going to effect some change in the short to medium term, but as with all justice reform, change reveals more evidence, shows us where else we need to pay attention to achieve improvements and reduce harm. We must also be mindful that such is the complexity of the web, each solution has both the potential for good and for unintended harm. Still, what we've talked to you about tonight shows that those currently being harmed by the process deserve our persistent poking of the justice tuatara from its safe burrow, using challenge, creativity and innovation to achieve a justice process that's more educated and responsive to the needs of those impacted by it, and that's open to the kind of community wisdom I've just talked to you about. So thank you so much for listening tonight. We're open to questions if there's time, and we also have a lot of acknowledgements that I think John might also talk about. And thank you to all of you, particularly to Lecretia's family, to our research participants. We hold what they shared with us as treasure. To the Michael and Suzanne Boren Foundation, they are the reason for the centre's being. They give us the funds. And to the Faculty of Law for the other reason for the centre's being, who also support us in lots of ways, monetary and otherwise. And also to all the places that gave us access to all of our colleagues who have, we've got so many colleagues who have participated in this research, and of course to the whole centre team, including Anna, who's amazing, who runs our lives, and all of our research assistants, some of whom are in the room tonight. So thank you.
Fantastic kōrero, and sending us away with lots to think about, but also just this karakia is about the ending of a day, about the slowing down of the rivers, about the slowing down of time, and just to relax, to lift the restrictions that sit upon us now so we can go and be back in ordinary life. Ka pai. Okay. Tokia, 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 te tamanui. Tokia, Tokia, te tamakotahi. Ki ngā roma whakatokia. Ki ngā awa atarere. Arumia te atawhai. Arumia te pai. Ka mākona kua mākona. Koropiko atu rā kia tau kia u. U tonu u tonu. Tuturu whakamaua kia tina. Haumie hui e. Taiki. Kia ora tātou.